The Companies and Allied Matters Act 1991 was first amended by the National Assembly in 2018. President Muhammadu Buhari, however, requested for a reconsideration of the bill and finally gave his assent in the month of August 2020. Now, this bill has been at the center of controversy. My name is Zainab Sanni, and I welcome you to this month's edition of Development Issues. Joining me to discuss this very important topic is Mr. Sanmi Abiodun. He is a corporate lawyer, and we'll be taking a look at how the Companies and Allied Matters Act, CAMA 2020, is going to affect businesses, is going to affect the Nigerian society, and is going to affect economic freedom in its entirety. Thank you for joining us on Development Issues, Mr. Abiodun.
Thank you, Zainab. It's a pleasure to be here.
All right. So people have been going on social media to talk about the CAMA 2020, and you see opinions flying here and there. But it almost feels as though nobody even gets the idea behind it. For example, we have the Child Rights Act, which is out there to ensure that there is no violence against any child, and all forms of abuse against the child can be redressed. What's the rationale? Because, of course, it's not even a new act.
It's not.
So what's the rationale for setting up that, or for putting together that act?
Primarily, in every sector of society,
Okay.
there's regulation. And for businesses, for companies, for any aspect of the economy that has to do with individuals and the way they make money for themselves, there has to be a body that is regulating it. In Nigeria, the body is the Corporate Affairs Commission, and the legislation that sets that up is the Companies and Allied Matters Act. This instant amendment is pretty much an update because it is understood that across the world there's a lot of development happening. And as other aspects of life are evolving, it's important that the business aspect as well is evolving. As the business aspect is evolving, it's also important that the regulation that is guiding the business aspect is evolving as well. I believe that's the rationale behind this update, to make it in line with global best practices, infuse a little bit of corporate governance issues, ensure that there's ease of doing business, because across the world, again, there's the global index for measuring ease of doing business in different countries. There's the World Bank Index. There's also the ease of doing business index. And this indices are used generally to measure what countries investors can easily go into to spend their money, to invest their money, and recoup their funds without so much bureaucracy. So I believe that is the rationale behind it for the federal government, ensuring that Nigeria is at par with many other countries globally.
You mentioned two interesting points, the global best practices and also the fact that it's for ease of doing business.
Absolutely.
We'll come back to that.
Okay.
But, Section 839 has been the only focus as far as this bill is concerned.
Yeah.
Meanwhile, you were telling me before we came on set that it has about 660 pages.
Absolutely.
So what are the key points, what are the key sections of this bill, of this act, that affects everyday Nigerians, that affects everyday businesses that we have within the Nigerian society?
Okay. So because, again, the law has been here for many years, I will not focus on the provisions that have always been there.
Okay.
I'll focus a little bit on those that are new.
Okay.
There's some infusions into this law that are very, very relevant, that bring the company's law, that is what is referred to in many other countries, that brings the company's law at par with global best practices. I'll try to touch on a few. Say, for instance, there are many things in Nigeria that we already do that are redundant in terms of registration or operation of companies. A classic example will be Section 330, which says that every private company in Nigeria, well, before this new law, it said that every private company in Nigeria should have a company secretary. The truth is, if I set up a company for myself and my wife, for instance, as the shareholders, both of us as the directors, both of us are going to run that company. It's a small company, but the law says we must have a company secretary. The question is, why do I need one? The entirety of the operations of that company is within my house. Why do I need a company secretary? But just because the law says so, I'll go and borrow someone from somewhere and say, you know what, I'm going to put your name as the company secretary for this company. It's redundant. So this new law has come to say, you know what, for private companies, for small companies, it is no longer mandatory to have a company secretary. Expunge it. So that's section 330.
And is that also the section that allows one person to be the only shareholder of a business?
No. So there's another provision for that. That is section 18, subsection 2, that says that now a single individual can be a shareholder and owner of a business. Previously, the law said that you must be at least 2. Again, redundant, because it is my business. I want to run it. Why are you forcing me to go and bring someone from somewhere else to become a shareholder in my company? If I don't need a second person, then I register the company, give myself 99% shareholding, give the person 1% shareholding. It's redundant. He doesn't need it. He's not going to do anything. He hasn't contributed anything to the company. But just because I'm trying to meet that regulatory provision, I bring in someone else as a second shareholder. There are many provisions like that. There's section 402 that talks about having an auditor. It's a small company, for crying out loud. We are probably not even going to do anything for the whole year. But the law mandates us to appoint an auditor to audit our accounts for the entire year. We don't even have accounts. Perhaps we didn't even do anything that year till the next year before we do anything. But this year, the law says we must have an auditor. So section 402 has come out to say, you know what? You don't need to have an auditor again for a small company. There's also the provision that says that small companies don't need to hold an AGM. There's the provision that says that small companies, private companies, in fact, can now do meetings online, virtually. Previously, it wasn't there. There's section 98 that says that every company, previously, for every limited liability company, you had to have a seal, a metal seal, company seal, which you affix on documents. We probably won't write any letter in the entire year. So
it's almost as though this administration, the Buhari-led administration in Nigeria, is very interested in small and medium-scale businesses, which is reflecting in some of these provisions that you have mentioned in the amended acts.
Yes.
And that brings me to, are you saying that in its entirety, this amended act favors businesses in Nigeria? Or are there provisions that businesses should be wary of?
So I would say the law entirely, it's an overhaul of the business landscape in Nigeria. To a large extent, it's in the best interest of companies, of businesses in Nigeria, to a very large extent. There may be provisions that small businesses, even big businesses, may have a challenge with. But that doesn't say that the entire law in itself is not in the best interest of businesses. Say, for instance, the Corporate Affairs Commission now has the right at any time to strike off or to withdraw a certificate that has been previously issued to a company.
No matter the number of years?
No matter the number of years. But again, there will be basis for it. So say, for instance, there is evidence that there was some fraud or some misrepresentation in the way the company was founded or the way the company was set up. Or say, for instance, it is discovered that a company, at the point of registering it or at the point of getting the name that it's using, there was an omission. Say, for instance, another organization exists with the same name or a similar name. There's the check that the CAC should have done at the inception to prevent that from happening, that duplication. But just in case it happens, the CAC now has the power to withdraw that name, even though it has previously approved it, and say, you know what, another organization is using that name, go and take another name. So there are these tiny provisions here and there that
might seem a little uncomfortable.
Yes, but generally, the law isn't doing business in Nigeria.
And you know, all of these tiny provisions that you mentioned that might seem uncomfortable, it feels like I already know, I mean, we all know, even though we don't say it, that law can be exploited.
Yes.
But could it not be unduly exploited or unnecessarily exploited by those vested with the power to, enforce it?
So what I see that this law has also done is that the law has provided checks and balances for itself.
Okay.
Many of the things that people have a challenge with this law are things that are not arbitrary powers of the CAC. As a matter of fact, the CAC has subjected itself to checks by the courts. So many things many powers that the Corporate Affairs Commission seems to have are actually just things that the Corporate Affairs Commission can initiate, but still needs to be ratified by the court. Even the Registrar General of the CAC is not all in all. There's still the Administrative Proceedings Tribunal that is set up to check and balance things.
So there's all around, there's some sort of balance that ensures that it is not abused at any point in time.
Absolutely so.
All right, you talked about challenges.
Yes.
And that brings me to the much touted Section 839.
Yes.
I mean, we have been talking about private organizations, the ones
Yes.
doing businesses. There are also private organizations that are not doing business or say
Yes.
they are not doing businesses.
Yes.
For example, non-profits and religious organizations. And they have come to describe this law as repressive. In fact, the socio-economic rights for SERAP, you know, they described it as a repressive law this morning still and asked President Muhammadu Buhari to withdraw his assent. What do you think about that?
So I'll start from the last thing that you said. His assents cannot be withdrawn.
Okay.
It's already been passed into law. If they need to challenge it, they go to court. Putting that aside, I believe that the clamor, the rancor against the law or referring to the law as repressive is rather misguided.
Okay.
The reason being, a critical look at the law actually does not say many of the things that are being touted that the law says. For example, the provision that people have a challenge with, that section 839, talks about the powers of the commission to suspend trustees or to appoint an interim manager for trustees of an incorporated trustees, NGOs, as we usually refer to it. The truth is, even that provision is not arbitrary because there has to be a basis on which the Corporate Affairs Commission will do that. And the basis is clearly stated. The basis is that there has to have been a petition by members of that organization.
Okay.
At least 1/5 of that organization members should have been the ones raising that petition. And that petition will be backed with evidence showing either gross misconduct by the management of the organization or showing that there has been fraud or that there is fraud in the running of the organization, or the commission can on its own raise that petition saying that we are trying to protect the property of the organization. Or, for instance, there's a provision that says, so section 839 subsection 2 is the one that talks about this requirement for members themselves to be the ones to raise the petition. But in addition to that, the Corporate Affairs Commission can raise the petition if it feels as if this action of suspending the trustees is in public interest.
Okay.
Say, for instance, the organization is doing things that are ultra-virus or things that are negative to public interest, or the organization is carrying out activities that could be harmful to people in communities. The Corporate Affairs Commission has the right to take those steps. And beyond that, even when those steps are taken and the petition is raised to the court. It's the court that sits on it and pronounces and gives an order.
It's not as if it hands them arbitrary power.
Not at all.
All right. Let me hold you, dear.
It's
you
fine.
know, you mentioned public interest.
Yes.
And every time I discuss Nigerian law or the constitution, one thing we find is that there's this broad use of language. General, you just, what do you classify as public interest? How do you say that someone is posing a security threat to public interest? How do you define those things? Are they stated in this law, in this act?
No. So public interest, indeed, like you have said, is broad. The easiest way to describe it is this. I have rights as an individual, fundamental human rights. You have rights as an individual, fundamental human rights. To the extent that I execute my rights, I am free. But the moment I start trampling on your own rights, I'm no longer free. So if an organization goes out of its own right to start affecting the rights of other people, whether or not there are multiples, whether or not there are many, it is already going against public interest.
It seems like you're out to convert all Nigerians to, you know, support CAMA 2020.
Well, I believe I'm just being objective because I see the rancor, I see the venom that people are pouring against the act, and I feel like the truth is there may have been elements, individuals who have tried to come out to incite this violence against government, not necessarily that people believe that the act is repressive. And I'll
Many
give the
people
reason.
don't even understand it.
You're right. But you said the reason is the major issue that has been raised against the act is more emotional than logical. But the truth is, non-governmental organizations, incorporated trustees, that's what they're called at law, they're way beyond churches and mosques. So by the time they make it seem like government is targeting churches, Christians begin to frown. Why is government targeting churches? But government is not targeting churches. Government is raising a regulation to regulate NGOs. Churches are a minuscule part of NGOs. Churches may not even contribute up to 1/3 of the NGOs in Nigeria. There are lots of NGOs. So this law is not targeted at churches. It's regulating NGOs. Churches just happen to be one of the set of organizations under NGOs. Take, for instance, the reason this is important is that NGOs generally, and this has always been in the law, NGOs are non-profits, which means when they make money, if they do anything that generates money, they're not meant to share the money among the members. The reason that is sensitive is because NGOs are free beyond what private companies can do. NGOs are free to raise money globally. So an NGO can say, for instance, now they are trying to combat HIV in Nigeria. They seek for grants. They get $100 million. They receive that money and share it among their members and buy private jets. There has to be a body checking that.
Are you saying that there are no parts of this law, like absolutely no parts of this act that anybody should be wary about, or that we should, raise or grumble about?
I would say that the act, to a large extent, represents global best practices. No one really likes to be controlled. Human nature. When we start feeling like we are being subdued or like someone is peeping into our affairs too much, there's the tendency to want to rebel. So I would not say that there are no provisions that people should pay attention to in terms of ensuring that they comply. There are those provisions. But to say that those provisions are repressive or to say that those provisions are going to pose major challenges for businesses, I would say no. I would say that the law is fair as it is.
And how do you see implementation, turning out? It's one thing, we have fantastic policies in Nigeria. How do you see implementation of this act turning out? Implementation
will be staggered. The truth is, and people may not be mindful of that yet, the law has not yet kicked in. Okay. It's been passed, but it has not yet been implemented. So what the Corporate Affairs Commission is going to do is that over time, they would take different portions of it and create policy guidelines and release public notices to say this is how this part is going to run, this is how that part is also going to run. But what is clear is that they are now empowered to do that. But the law has not even started being implemented at all. None of these updates, I mean. The previous law is still in force. Now there's a new law, but implementation hasn't started. I believe that it's going to be staggered over time. They'll bring in one part here, release a policy guideline for it, another part there, release a policy guideline for how it's going to run.
All right, thank you so much, Mr. Abiodun, for your time. It's been a pleasure having you on development issues. And I'm sure that our listeners have learned, or our viewers have learned one thing or the other about CAMA 2020. And that is it on this month's edition of Development Issues. I hope that as you go about your daily business, you take time to understand CAMA 2020 to ensure that you do not just go on social media to write out of ignorance about the act. My name again is Zainab Sanni.